Good afternoon, everyone, and thank you for joining us for our webinar today, The Top Employment Law Issues Impacting Startups, presented by Littler and Early Growth Financial Services. This webinar is going to be approximately 60 minutes with time for question and answer at the end of the presentation. I encourage you to use the questions panel in your GoToWebinar console in your screen. We'll review as many questions as we can at the end of the webinar. Those we can't get to, we'll provide some contact information so that you can reach out afterwards. There will be a recording of this webinar made available to all registrants within 48 hours of this webinar, so that will be available to you for repeat viewing if needed. So without further ado, I'd like to introduce our presenter for today from Littler, Kayvan Iradjpanah. And
hi there.
Kayvan, thanks for joining us today. You've said hello, please, after you.
All right. Well, thanks, Jason, and thanks again to Early Growth Financial Services for facilitating this webinar. It's our first collaboration, and we're super excited to do this, and hopefully there'll be some useful information for all the listeners online. As Jason mentioned, do feel free to type in questions as we go through. There's a lot to cover. If you run out of time, or if I don't cover something that you're curious about, by all means, feel free to send questions after. They'll get to me, and I'll be sure to get back to you. Before I get started, I wouldn't be a lawyer if I didn't have a slide like this with an exclamation point and a caution sign. And this is stating the obvious that, the purpose of this webinar really is to give you some pointers and some high-level thoughts on things you should consider as you begin to scale your startup or company. So it's not meant to be legal advice per se, and particularly for this webinar, because it's national in scope, employment law is highly state specific. And so we're going to address these topics in broad brushstrokes, but it's not intended to be legal advice. If you do have specific questions, I do encourage you to seek counsel, whether it's me or somebody else, to help you. Before we get started, some quick background here. Littler is a national, now international law firm. We have over 70 offices throughout the country and the globe, all focused on employment law. We're the world's largest law firm dedicated solely to employment law. Most of our clients are Fortune 500 companies, bigger companies, lots of employees, but there is definitely a handful of us, myself included, who are really trying to reach out to startups. And so very much our work is defending companies in litigation, whether it's failure to pay wages or wrongful termination. But very often for startups in particular, it's advice work, helping them design employee handbooks, designing a structure that will be compliant and reduce the risk of lawsuits. And really here, in my experience and the way I got involved in all this, despite working with these bigger clients, is I had so many friends in the startup world. And very often the things you hear about are corporate law and intellectual property law. And employment law is rarely part of the conversation. And I think the reason why is people have this perception that, my priority now is to scale, to get funding, to actually have a viable business. And employment law is an ancillary thing that I'll deal with later. And the problem with that approach is that small businesses are not immune from most employment law. In fact, most laws, especially in the wage and hour arena, apply to you equally whether you have 1 employee or 1,000 employees. And the difference is a larger company has an HR department, they have legal counsel, they can afford to defend themselves in lawsuits at the cost of doing business. But for a small company, that can have really big ramifications. I just had a startup client a few weeks ago who got audited by the tax authorities here in California because they had all these independent contractors, and the tax authorities said, well, no, wait a minute, some of these folks should have been employees, and you should have paid taxes, payroll taxes for those people. And that's going to be a really tough situation for that small company. They only have 8 workers. So the theme for today is to give you guys some tools, some things to think about that can help you structure at the outset. And I think there are definitely some ways you can do that very cost efficiently, whether it's with an attorney or with an HR consultant or otherwise. So you at least have a foundation to build upon and minimize, risks later on. So with that said, our goals for today. First, to provide a basic overview of applicable employment laws. There is way too much to cover in 1 hour, but I try to highlight some of the key issues that seem to come up time and again for a lot of my startup clients. 2, to review the top issues facing startup companies. To discuss tips for employee onboarding. So very often the question I get when I do these seminars is, okay, well, I get all the issues. What do I do now? How do I address this stuff? And so we'll talk about that toward the end. What can you do, whether it's implementing policies, an employee handbook? So we'll go over that a bit. And then question and answer. By all means, ask questions throughout the presentation, but I'll try to get through this with enough time for us to ask some questions at the end. And of course, if you have specific questions, you're always welcome to talk to me offline. I'm happy to address them for you. So with that said, I think it's important to talk about the legal landscape for a minute or two. And the basic idea here is that, in the United States, we have very state-specific legislation. So employment law, more so than many other areas of law, is derived from statutes, from laws that the legislatures have passed. And so I'm here in Los Angeles, in California, and California undeniably has the most protective laws of any state for employees. Things that we have here, like getting double time pay, there being penalties for meal and rest periods. Those are getting overtime after 8 hours in a day. Those are concepts that don't exist in a lot of other states. So it's really important that you know which state you're in and make sure that your policies are compliant. A couple quick examples. Non-competes are generally unenforceable in California, not so much in other states. In California, you can't have a vacation policy, a use or lose it, which says that you lose your vacation if you don't use it in a year. Not the case in other states. So that's just an example of being really cognizant of what you're looking at. And I've had startup clients who will send me their employee handbook, and let's say they're based in California, and I say, well, where do you get this? And they'll say, oh, I just Googled it. And I say the problem there is this handbook is for Arizona, and compared to California, they basically have no laws in Arizona in the employment arena. It's a totally different an atmosphere for employers. So that's really important. With that said, there are federal laws, and if you Google stuff on employment law, you'll find websites talking about federal law. But generally speaking, when the state law is more protective, like if you're in New York, like if you're in California or other states, the state laws will control. And the context here is employment law is a really quick and fast-growing area of the law. A reason why firms like Littler have grown exponentially is because employers are being bombarded with lawsuits left and right. And I will tell you that I think tech, for those of you in the tech ecosystem, is often viewed as a new frontier for employment lawsuits. It's no secret if you look at the kind of new tech economy, there are all kinds of lawsuits against big tech companies, especially those that have independent contractors. And there's no shortage of theories that employees or contractors can assert against their employer. So this slide here just gives you a quick snapshot of a variety of different areas that employees could potentially sue you for based on the state you're in. In California, for instance, there are tons of lawsuits about the pay stubs, that the pay stub is not properly itemized. And there are penalties that are very unforgiving for that kind of thing. Other states have similar things that are very technical. And again, I think small businesses in particular are at a disadvantage because they don't necessarily have the resources to know what these rules are. But we'll talk about some things you can do to make sure you're fully aware of what you should be doing. So with that said, we can kind of dig in here. And the first issue, and in my mind the most significant for the tech ecosystem and startups in general is independent contractor misclassification. The idea here is that if someone's performing services for you, there's a question of, is that person a payrolled employee of your company, or are they a contractor? And calling somebody an employee or a contractor doesn't end the discussion. It's really an analysis of what the person is doing day in, day out. And so a lot of lawsuits are called misclassification lawsuits, meaning that you might have called this person a contractor, but that they're only a contractor in name. That if you look at their actual day-to-day duties, they should have been an employee. And to give you an idea of how this works conceptually, I'll use a couple of examples. An employee is that classic example, let's say, of somebody coming in with a set schedule, 8 to 5, at your direction. They're not working for anybody else. They're not a business owner. I think we all kind of have an idea of what's the classic example of an employee. And to put that on one end of the spectrum, then on the other end of that sliding scale, that spectrum, you have a contractor. And the classic example I always like to give is a plumber. Somebody who comes into your house or your workplace because there's a clogged toilet, let's say, and they fix it, and you pay them, they invoice you, and they go. And they might see 20 different customers that day, and you might call them and they say, well, look, I can't come in today, I'm busy, and it is what it is. So we can all agree that plumber is a contractor. That person's not your employee because they came in and helped you out for an hour. But in the middle, there's more of a gray area for whether somebody is a contractor or employee. So it's no secret that a lot of these companies, for instance, that have replaced the traditional taxi model, not to name any names, but you know who they are, there's lots of litigation over whether those drivers are contractors or employees. And there's no shortage of examples of companies who are in the middle of that tug of war. The significance is, a lot of times companies prefer to use contractors when they can because they're not employees. And therefore, there's no obligation to provide workers' compensation coverage. There's no obligation to provide unemployment insurance. You don't pay payroll taxes on those people. Technically speaking, if they're not an employee, employment laws don't apply. So there's no obligation to give breaks or overtime or whatever your particular state or locality requires. So that's the advantage for businesses. And then by the same token, a lot of times contractors, people come and they prefer to be contractors because they're more flexible. Tax-wise, they're paid via 1099, which means that there's no payroll taxes being taken out of their pay. So a lot of times, their preference is to get the full amount, not the reduced amount after deductions. Some people who are true independent contractors can work for company A and company B and company C and do their own thing. They can even find other people to help them, subcontract. So, there's definitely advantages on both sides to having contractors. But the issue is, is somebody a contractor, which we'll get to in a minute, and what happens if you misclassify somebody as a contractor? And the first thing is you could get potentially audited. The example I gave a few minutes ago, the IRS, your state's tax authorities, the Department of Labor, they are aggressively engaged in audits of employers or companies looking at whether their workers are contractors or not. So in the case of the company I just mentioned a few minutes ago, they're a 9-person startup, and one person left and lodged a complaint, and that triggered an audit. And this particular agency is not, what they're saying is they're not looking to give major discounts because they're a startup. They're saying we're the tax person, and there are certain rules and penalties, and they're being very unforgiving about it, and it's a very unfortunate situation. So that's the kind of situation I think, if you can take anything out of this, you want to avoid. There's also litigation, the idea that there are lawsuits where people say, I should have been an employee, not a contractor. Therefore, you owe me all the overtime I worked. You owe me all the meal breaks I should have gotten if you're in California or a state that has meal break rules, and et cetera, et cetera. So there's all kinds of potential liability there. And in California, for example, and other states, there are penalties where if somebody determines you willfully misclassified somebody as a contractor, in other words, you had good reason to believe this person should have been an employee, and you went ahead and made him a contractor anyway, there are penalties, in California at least, up to $25,000 a person. So as you can imagine, this is pretty significant stuff. And so this comes to the question of, when is someone an independent contractor? And if there's one thing lawyers love, it's these multi-factor tests. Any question you ask a lawyer, the first thing they'll say is it depends. And I know that's very infuriating. But the reason why is because you have tests like the one before you, where the law says, there are all these factors, and you view this person against these factors, and they're either a contractor or not. And so there are certain examples, like if you came to me and said, I have somebody coming to my office 8 to 5 every day coding, I would tell you in all likelihood they're an employee, unless possibly they're project-based. But there are some other gray area rules. And then to complicate things, every particular forum, every agency involved has their own test. So if you're before the IRS, they have their test. If you're before the federal government and employment law, there's a test there. If you are before your state's particular labor commissioner or agency, they have their own test. And so you have to be mindful of which place you're in. But if I could tell you there's one overarching idea behind this analysis, is control. The more control you have over somebody and what they're doing, the more likely they are to be a employee and not a contractor, despite whatever you might call them. And so the slide before you has a patchwork of factors that different agencies look at. And first and foremost, the first one is the right to control the manner and means of accomplishing the result desired. Another big factor here, the second one, is whether the person performing the service is engaged in a distinct occupation or business. So for example, if you're going to contract with a PR agency to help you with a particular event that's coming up, depending on the structure, it's very likely that arrangement's a contractor relationship. That person, that agency might have a business license. They might invoice you. They might have a number of other clients. But if you have somebody that's working for you 20 hours a week indefinitely to help you with your PR, that might be more of a situation where that person's probably an employee. The next factor, the kind of occupation, and particularly whether in the locality the work is usually done under direction of the principal. And the next one, the skill required. So the idea here is that, let's say you are your particular company is primarily entrenched in programming, like you do programming for other companies. And then you start getting all these contractors that are programmers to help you. Well, the risk you run there is that an agency might say, well, wait a minute, you're in a programming business. So it's not like that plumber example where you have some ancillary task that needs to be done and you're hiring a specialist to help you. These are people that are helping you accomplish the core of your business. And, that is a factor that could weigh against you. Whether the principal or the worker supplies the tools and place of work. So if you have people coming into your workplace hours on end, day by day, that could be a situation where it looks more like an employee. And so on and so forth. The other thing I've noticed with startups is they might have contractors and employees, and there's no real distinction between the two in practice. So they'll give the contractors an offer letter that calls them an employee. That's obviously a big no-no. They'll talk about hiring independent contractors. That's not really the right vernacular for that kind of situation. They'll have team meetings where they have employees and contractors, and you might not even know who's who. These are all things that are going to work against you in the analysis of whether somebody's a contractor or employee. So when it comes to determining what to do in your situation, I would say first assess whether the worker should be classified as a contractor or not. And look at those tests that I have in the slide or elsewhere. If you have questions about where to find particular materials, just shoot me an email. I'm happy to direct you. Talk to an attorney, talk to an HR consultant, somebody who can help you. I fully am cognizant of the limitations that startups have. And I have a lot of startup clients that tell me, look, I can't afford to have these employees. The contractor relationship is, a more viable path to my business? And I fully get it. And I don't have a great answer other than go into it eyes wide open, because, at the end of the day, unfortunately, your financial limitations are not a true defense against whether somebody's a contractor or not. So you have to be judicious with perhaps how you strategize as to who to classify what.
So, Kayvan, a question, real quick question for you here.
Sure.
If anybody's listening to this and they've got contract employees right now and they're realizing as they hear this, like, oh man, these should actually be employees. Are they in trouble at this point? Do they have means to rectify without substantial penalties? If there's it was an honest mistake in how they classified this, how do you typically advise companies that kind of have that come to Jesus moment where they're like, oh, these are actually, I need to make these people employees to be, on the right side of the law here?
I totally get it, and it's a great question, because if I'm being honest and frank here, I think it's almost kind of like an industry practice where a lot of startups have contractors. That's what they all do, and not appreciating that maybe that's not legally correct. So to answer your question, Jason, I would say that you have to be judicious. I mean, the tough balance is if you as an employer kind of concede that what you've been doing is not correct, that could potentially be used against you should something happen like litigation. And so what I would say is if I were in the shoes of somebody you just mentioned, I would do a sober assessment of who you think potentially has been misclassified. And I think the best route, and it really depends on a particular situation, but I've had clients who basically sat down with those individuals and had a conversation, and they've decided to classify them as employees going forward. And, to the extent there is some concern about the past, I mean, there's no real fix. I mean, you could potentially, I suppose, try to compensate them for, what might have been owed that wasn't paid. But I think the better option would be just to reclassify them as employees after having that conversation. And to the extent you're concerned about, let's say, somebody who could potentially sue you and you think might do that, some clients decide to have some kind of release or agreement that wipes the slate clean for them. So there's not a great, black or white answer to that question. But I have dealt with it before, and I think, there's definitely a path forward for those who are concerned.
Great, thank you.
Sure. And I think the next thing is having a legally vetted independent contractor agreement. And a lot of times people pull things offline that they find for free, and they just have it signed and don't really read the independent contractor agreement. Do read that agreement, because if there's an audit or a lawsuit, that's the first piece of evidence that is assessed, is what does the contract say. And case in point, that audit I just mentioned, there was a provision in there called work made for hire, which basically said that any work product that the contractor develops becomes a property of the company. And in California, for example, the tax authorities automatically view that as, many of them, unfortunately view that as evidence of an improper contractor relationship. And there are ways to address that concern outside of that provision. My point for saying all this is, it behooves you to have a reliable template agreement that you can go off of for a variety of reasons. And then finally, manage the relationship in a legally defensible manner. Have an idea of, what the contours are of a proper employee versus contractor relationship, and then walk the walk. Don't refer to your contractors as employees. Do have some kind of demarcation for who's a contractor and who's an employee, because that is ultimately what's going to make the determination of whether somebody's a contractor or an employee. The next area is exempt classification. And the idea here is that in California and federally, in pretty much every state, the baseline rule is that employees are entitled to overtime pay. And in some states, they also are entitled to breaks, legally entitled to breaks. But there are certain categories of jobs that are exempt from those requirements for overtime. and those are called exempt positions. So there's non-exempt, which means you're entitled to overtime, and exempt, which means you're exempt from overtime. And similar to the independent contractor concept, just because you classify somebody as salaried exempt doesn't make them properly salaried exempt. It boils down to what are your job duties day in, day out, and does that place you in one of those categories of positions that makes you exempt? So, for example, I'm an attorney. I certainly work more than 40 hours a week, and I'm in a professional category that exempts my firm from having to pay me overtime. So I definitely don't get overtime pay. As part of my salary, it's assumed that I'm working overtime. And there are some days I don't take a lunch because I'm so busy, and that's okay. So very often, a lot of my cases, my litigation, centers over this issue of exempt classification. And so if you have people that are employees who are salaried, you have to look at whether or not they fall under one of these exemptions. And there are a variety of exemptions under federal law and in each state. So for example, in federally, there's an executive and administrative exemption. And those are exemptions which basically say that if you are a high-level manager who has hiring and firing authority of some sort, and you're managing 2 or more people, or for the executive exemption, you could qualify under that exemption. But very often I have cases where there's back and forth as to whether that person's truly exempt. So I had a case, for instance, it was a grocery store where the manager stood and said, look, you call me a manager, but I spend half my time spraying the vegetables and sweeping the floors and doing the work that others are doing who are my subordinates. So I would say, generally speaking, you have to be very judicious about who's exempt and who's non-exempt. There are other categories: employees that are commissioned, employees that are engaged in outside sales, employees that are in the computer software field. And this area is so vast and is so state-specific that it's hard for me to really get into nitty-gritty now. But if you have any questions, I'm happy to try to direct you to some resources that can help you at least familiarize yourself with the factors involved. So here again, what can you do? First of all, if you have exempt positions, be mindful of how you project what those positions entail in the job descriptions. In litigation, the first piece of evidence I oftentimes see in these cases is the job posting. If the job posting reflects non-managerial work, that could work against you if you have a manager who's classified under one of those exemptions for managers. Similarly, if you have an offer letter, that offer letter should clarify whether the person's exempt or non-exempt, because sometimes employees don't know, sometimes employers don't know, and that can be very risky for you if you're ever challenged in that arena. And then potential liability can begin accruing as soon as the employee begins performing work. So much like the contractor situation, the idea goes that someone might sue and say, you called me exempt, but I'm really non-exempt based on my duties. Therefore, all those days going back, let's say 2, 3, 4 years, I should have been paid overtime, and you didn't. So I'm going to get the overtime, I'm going to get the penalties. In California and other states, you might be able to get penalties or penalties for missed breaks. There's a whole gamut of potential issues for you. So again, be cognizant of this, and before you just go ahead and classify somebody as salaried. The third area that I think is huge for new companies is internships, and whether or not they should be paid or unpaid. And my guess is most people on the line here were like me, and at some point in their careers or when they were students, they had an unpaid internship. And that's not to say that unpaid internships are unlawful under state or federal law. That's definitely not true. But over time, the requirements for whether or not an internship should be paid or not paid has gotten a lot stricter, especially in certain states like California, but I would say generally across the country. And the idea here is that, is the work you're performing work that should be paid, should be compensable pay? And really this kind of got into high gear in the entertainment industry. And it started here in Los Angeles, but it's really reverberated throughout the country, I think. And you had, a bunch of different entertainment studios who were being sued in these class actions by their unpaid interns, saying that, these studios, these companies, received benefits from these people that were performing unpaid work that should have been paid to these employees. And so now there's a growing wave of lawsuits challenging unpaid internships. And I would venture to say that most big companies now are really hesitant to have unpaid internships. They'll pay minimum wage if they have to, but they want to make sure that they're not, potentially sued or liable for unpaid wages. And so this slide gives me a picture of a recent wave of lawsuits, class action lawsuits in particular, against a lot of companies who were doing this. And that's not to say these companies broke the law. There's a settlement, we don't know. But a lot of companies now are not doing this. And so here again, we have a multi-factor test, because that's what lawyers like. And the idea here is, there are a variety of factors that go into determining whether somebody is a proper, bona fide, unpaid intern. And this test is a California test. Other states have different tests, and it's impossible to summarize all this in one slide. But some of these factors carry over in most other states and federally. And I think the primary idea is an unpaid intern cannot displace regular employees, because the legislatures say, look, this would give employers every incentive to find unpaid people to do all the legwork for a business. And you might say, well, look, I have college students or other people lining out the door to work for me for free. And it's a resume builder for them. It's a win-win. Why can't I do it? And unfortunately, just because somebody wants to become an unpaid intern doesn't provide you with a full defense if it's challenged. It's just the way it goes. And it's unfortunate in some ways, because I think it prevents a lot of startup companies from providing exposure to what they're doing to students and other people. But at the end of the day, this is risk analysis that you have to do for your business. Certainly, it's important to memorialize with your interns, if they're unpaid, that they acknowledge and understand that they're not entitled to wages during the internship period. I advise most of my clients, especially startups and some new companies, to have some kind of written offer letter or framework in place. And most companies that still do this, I would say, make a big effort to create a curriculum where the internship is framed more as a training for the person rather than that person performing core functions for your business. So it's certainly okay to give an intern hands-on experience, but the idea should be more that it's a benefit for them rather than for you. I think that's really point number 6, the catch-all idea behind this provision. So in terms of next steps for you and what you can do, for many people, and again, this is state by state, it really depends. I can't purport to be an expert for every single state, but I think generally speaking, if you want to be very conservative, paying minimum wage is the safest way to go, because at that point, there's no question that you at least pay them for every hour on the clock. Granted, if they're working more than 40 hours a week or whatever your state's particular law is, you might have potential overtime and other things, but you have to be mindful of that. Though to be fair, if you have an intern spending 60 hours a week, that presents a whole host of other issues. It might really challenge the notion that person is a proper bona fide unpaid intern. But that notwithstanding, I would say number 1, if you want to be very safe and you can afford it, you could pay minimum wage. 2, do not replace unpaid interns with employees. If you have a framework where you have, a 1 month an intern, next month an employee doing the same exact kinds of things, that will be evidence used against you. I think definitely establishing a definite and finite time period for internship is important. If it's indefinite, that will work against you, because it pushes back on the notion that this is really more of an educational training experience for the intern. Number 4, tailor trainings to be general rather than targeted to the immediate advantage of the business. And so I'll give an example. My last year of college, I did have a paid internship for a big company. It was minimum wage, but I got paid. They had brown bag lunches once a week with different departments where they talked about, what they're doing and all other kind of stuff. And so that really kind of helped frame. Now that I'm an employment lawyer, I kind of see why they did it that way. It helped kind of frame the experience as more of an educational opportunity for me as the intern. Closely supervise and train employees. So number 6, I skipped that one. Notify the intern that you are not promising a job at the end of the internship. That doesn't mean that you can't hire somebody who ended up being a great intern. Definitely not. But if across the board there's the idea that this is your entryway to the business and your only entryway to the business, that would be used against you. Number 8, facilitate course credit from local colleges. If you always wondered why so many internships are contingent on course credit, this is one of the reasons. Facilitating course credit does not necessarily give you a full defense, but it really does, I think, again, frame what you're doing as more of an educational experience, a training experience for the intern. And number 10, I think, again, more of a catch-all factor, keep the training general and not to the immediate advantage of the business. So for those of you who were in the corporate world before you founded companies or became involved in startups, you may have gone through sexual harassment training in your workplace. Some states like California have requirements for sexual harassment training, others don't. I don't mean to get into this too much because at the end of the day, you can spend 3, 4, 5 hours just on this topic alone. But I do want to give a picture as to what the issues are, because very often I have somebody come to me and say, can my boss do that? Can they fire me? Or can I fire this person? And would that be wrongful termination? And generally speaking, the idea is in the United States, unlike many Western industrialized countries, employment is at will. Different states have different concepts regarding that. But in most states, and again, check your own state. I can't speak to all 50 states at this moment, but California, for example, despite it being the most protective state for employees, is an at-will state. And at-will means that you can be fired for any reason, so and an employee can leave for any reason, so long as it's not an unlawful reason. So, for example, if you want to fire somebody because they're not doing a job, or because it's not a good personality fit, or because it's not a good fit generally, that's permissible. You can do that. But the question becomes, if it's unlawful or not, is whether there is a nexus, a link between what you've done, that adverse employment action on the left, that demotion, that reduction in pay, that termination, that suspension, whatever that you did, it was adverse to that person. Is there a connection between that and some protected category, something they did or something about who they are? Because that's unlawful. And classic example federally is, there are different categories in place under Title VII, the Civil Rights Act, that prevent you as an employer from discriminating against somebody. So, for example, you cannot fire somebody based on their race or color or religion. You have the Americans with Disabilities Act, which says you cannot fire somebody for being disabled. And so most people on this call, I think, understand that and realize that. And so when it comes, and other states have different requirements. So in some states, it's not unlawful to fire somebody on the basis of their sexual orientation. In many states, that is unlawful. So look into what your state's requirements are. Other things, if somebody has complained about the conditions of their employment, like their wages or safety conditions, and then you fire them, that could potentially be unlawful whistleblower retaliation. So really, when you're going to take action because somebody's not doing a good job, or let's say you have to lay somebody off, think about, is there an issue here? Is there the potential for somebody to challenge the termination and say, well, I think this is because of X, Y, or Z? And so there's all kinds of stats I won't get too bogged down in, but the EEOC, the Equal Employment Opportunity Commission, which is the agency that oversees the Civil Rights Act, Title VII, they are getting all kinds of complaints of discrimination every day. And clients of mine have to deal with that and assess what happened. So it really comes down to, I think, identifying what's an adverse employment action. That's a thought process, step one. So you see here things that are obvious, adverse employment actions. Second is, how can I make sure that the actions I'm taking will not be perceived to be discriminatory? And the key golden rule here is any action you take should be motivated by a legitimate business reason. That's identifiable with respect to the position you have. So, for example, maybe it's because you guys, your company had a deal that fell through and you don't have the money to pay the person. Maybe it's performance-based. But first of all, consistency is really important. So if a client asks me, I need to fire somebody, what do you think? And I'm going to fire them for X, Y, or Z reasons. My first question is, have you fired other people for X, Y, or Z reasons? Or have there been other people who've engaged in that kind of behavior who weren't fired? Because the second there's inconsistency, there are going to be questions like, well, why me? Why was I targeted? The second thing I would say is, and again, this is common sense. Most of you know this, but important to bear in mind. Having documentation in place, a paper trail, is very important. Because if a termination is challenged, you as the employer, might have a burden at some point to show that your reason was legitimate. And if you don't have anything in writing, anything to document what happened, that's a problem for you. It might be harder for you to convince somebody that what you did was correct. And so a lot of employers have performance evaluations. They have, things of that nature. I get that for a lot of you in smaller companies and startups, it feels really impersonal and against your kind of cultural value to have, written warnings and disciplinary documents and all that. I understand that, and there's no one-size-fits-all approach. But I would say at a minimum, if you're having problems with somebody, think about, at least documenting the issues. If there's somebody who's been there for a while, you could do a performance improvement plan. There's a variety of things you can do to establish a foundation for what's been happening. And that might be a good time to consult an attorney briefly to help you game plan the best way to put yourself in the best position to dispel any, idea of unfair treatment. So same with idea of harassment in the workplace. There's a lot of press about tech and Silicon Valley, and that it's a male-dominated atmosphere. And, a lot of us have read those articles, and that can be an issue. And I think when it comes down to it, it's important that you, if you're a founder or a manager, give an idea of how people are being treated, what they're talking about. I realize we don't want to have very rigid restrictions in our environments, and a lot of you guys probably don't have traditional workplaces in a corporate sense. But at the end of the day, if you have people making comments that are lewd or potentially sexist or misogynistic, that could be an issue for you, and the employer can be held liable for that. Even if it's not directed toward that person, if they're in an environment where they feel intimidated or are offended. So I would leave it at that in terms of harassment. I think that's a big issue, and I don't want to go into it too much, but just bear in mind the environment that you are fostering in your workplace. Because believe it or not, these issues do come up quite a bit, even for smaller companies and startups. And last thing I'll say here is I think this is where an employee handbook really comes into play, because every employee handbook that I do, pretty much everyone I've seen has a section on being an equal opportunity workplace, and they have a procedure in place for whether an employee, if an employee feels like they've been harassed, what they should do. And very often, if you have these allegations in litigation, the first thing you'll look at is, was there a procedure in place for the company to address these concerns? So this is another reason to have policies in place. Kind of closing out the remaining issues here, remote workers. A lot of you, I would say maybe even a majority of you, might have workers that are not physically co-located in a place of business. Totally fine. That's the future. It's increasing exponentially year by year. Nothing wrong with that. From a wage and hour perspective, the risk that comes from having remote workers is that you're not there to oversee what they're doing. And so to the extent they're being paid hourly or should be paid hourly or should get breaks or should get overtime, there may be a question of, okay, well, how do you track their time, or how do you know what they're doing? Or if they come back to you at some point a year later and say, I worked 90 hours a week, do you have a framework in place to say, well, no, they didn't, and here's why? So definitely think about that. And if any of you have questions about that, I'm happy to give you my perspective. I have some clients who've found ways to, in a very non-intrusive way, be able to track their employees' time. So they have an answer for that question if it comes up. By the same token, and I think pretty much every state, there's workers' compensation, meaning that if somebody's injured in the workplace, they could potentially tender a claim to a workers' compensation insurance carrier. But if someone's at home and they get injured, if they're on the clock performing work, that could be a workers' comp claim. But what if they're at home and they trip over the stairs because they went to get a sandwich and they weren't doing work? Well, you can see how having remote workers creates a gray area. And so some clients of mine, depending on their size, will actually have a policy in place for the remote workers to kind of demarcate these boundaries about what's work and what's not work, to prevent somebody from potentially taking advantage or from having these gray areas. The last major area I'll quickly go through before closing this out is the idea of hiring and social media. And at the end of the day, let's be honest, a lot of us, when we meet somebody new, probably most of us, might look that person up on the internet, whether it's LinkedIn, whether it's Facebook, whether it's Google. And there's nothing unlawful about doing that per se. At the end of the day, recruitment's done through LinkedIn as much as anything else these days. But the risk becomes for you who are hiring is if you've come across information through the hiring process on social media, then you've been now charged with that knowledge. And so, for example, let's say you learn through Facebook that somebody has a disability and you don't hire them, and then they challenge your decision in court, you're going to have to say, well, yeah, I was aware of the disability. And of course, you'll say that that was not a factor, and of course, that wasn't a factor, hopefully. But now you put yourself in a situation where you would have been better off being shielded from that information. So I would say hiring with social media is a double-edged sword. You can find very useful stuff, totally fair game, but you have to be cognizant of the fact that you could learn information that you would normally go out of your way to avoid. If you're hiring people, you hopefully will not ask things like, do you plan to have any more kids, or what religion are you, or this or that. That is stuff you can easily find out through internet searching. So, for example, the useful, seeing photos of people engaging in behavior that's not appropriate or that you would not want around in your workplace. Social media, internet can definitely help with that. Totally fine. Downside, you can learn all kinds of protected category information by going on the internet and searching people. So a couple of quick examples here, traditional kind of Facebook wall, you learn somebody's political affiliation, some of their other viewpoints. It could be too much information for you to have or want to know during the hiring process. Some other examples, someone tweeting, I came out to my family last night, really uncomfortable stuff. That could potentially be a hotbed issue. The rest are kind of self-explanatory. I won't go through each one, but be mindful of what you're doing. So, to close this out, I think the biggest issue becomes, what can I do as a new company to traverse all these landmines that are employment law? And I am completely practical when I say this. I fully acknowledge that for a lot of you have limited resources. You cannot afford to hire counsel every step of the way to help you on issues. You're not a big company like that. So I think when it comes to what you're doing, first and foremost is having policies and procedures in place that can help be a guidepost for you. They can help guide what you should be doing. They can help guide your employees for what they should be asking about. and they can help be an initial layer of defense for you if there's allegations that your company did not have a policy for breaks, or your company, for instance, did not have a procedure for raising concerns in the workplace. So compliant policies really are evidence, I would say, that you've informed your employees of your intent to follow the law, and they're critical. For bigger employers, the policy documents, if they're incorrect or not compliant, have been in many instances the reason why they've had class action lawsuits, because there's evidence of some systematic practice that's not proper. Even for smaller companies, it's been an issue for them in litigation. There is no question not having the right policies can be used against you in litigation. And so be very mindful. There's a temptation to go on the internet and just download stuff, but you might not have any true appreciation for whether that's compliant in your state. I have clients, startup clients, who have non-competes that are unenforceable in California. I have clients who have arbitration agreements that are not compliant in their state. And arbitration, for instance, is a topic that it's so quickly evolving that the agreements I did for somebody 5 years ago might not be compliant now. And so those are things that people have to update all the time. So there's a good chance if you go on the internet and find something, it might not be the right fit for your operation. Case in point, I cannot tell you how many startups I work with, some of whom are part of accelerator programs or, really kind of upper echelon companies who have funding and are working with mentors and law firms, and they'll have some termination issue, and they'll give me the employment contract for that person. And I look at that contract, and it'll, so let's say it's for a part-time programmer, nothing high level, not a huge equity stake. And that provision, that contract has a provision saying, termination for cause. And I'll ask them, why on earth do you have this contract? Because these kind of contracts are really meant for higher level CEOs. Most employers would not have a for cause provision under, for a regular employee. And they'll say, oh, well, I just went online to some law firm, portal, and I downloaded it. And it could very well be that contract is legally compliant, but just not congruent, not a good fit for that particular employee. So be very, very mindful. If I can give you any advice out of this more than anything else, be very mindful of what you're downloading, what you're finding, with respect to whether or not it is a right fit for you. And I think that, a little bit, if you can afford it, again, whoever it is, whether it's an attorney, HR consultant, somebody, if you're able to at least put aside a little bit of resources, whether it's hiring somebody, educating yourself, something now, may save you lots of money and headache down the road. The way I see it is, this is your opportunity, for those of you who are more early stage, which I think is most of you, to build a foundation for your business. To give another quick example, and again, it's not meant as a scare tactic, it's actually real life example. Another client I had, they came to me, they were in the stages of being acquired by a larger company. And very often employment law is not a deal breaker for acquisition, but in this case it was, because the acquiring company looked at the startup's payroll and said, look, you have one founder and 9 contractors. In no universe would that, pass the BS detector test, right? And that's a risk for us, because if we take on your liabilities, you could have a few of these people sue going back 3-4 years. And that's a real life example of, I think, a situation where, a decision not to worry about the stuff on the front end really hurt them on the back end. And what I think even harder about the situation I just mentioned is that in that situation, they could have structured the employment of their workers in a way that would not have cost them that much more money. It was really more an issue of structuring their agreements, having a handbook in place, doing that stuff on the front end, which they didn't do. So if I can tell you anything, I would say really take a hard look at what you're doing, and find areas where you might need to have somebody help chime in terms of getting compliant. So with that said, I know I went through things very quickly, but if you have any questions, feel free to ask them now. We have about 5 minutes left. maybe a little bit more. I'm happy to stay on. And then by all means, if you have specific questions, definitely feed them through and I will get back to you.
Great. Thank you, Kayvan. That's fantastic. Just as a reminder to everyone, you can use the questions panel in your GoToWebinar console. So to get your questions in, we'll try to knock out a couple here beforehand. And of course, if we don't get your question here, Kayvan's email address is right there on the screen, so you can follow up directly afterwards. Kayvan, one question for you.
Sure.
You know, we did go through a lot there, but what are the common mistakes that you see? Not necessarily the super critical ones, but you know, common pitfalls that you see these early stage companies kind of fall into with this.
I would say one is what I just mentioned. I think number one is downloading documents, handbooks, things that are not applicable to their employees, and then basically entering into policies and contracts that are just not correct. I would say that's first. I would say independent contractor misclassification is second. It's kind of risky business, and some have to do it, I understand, but that is very common, I would say. I would say number three is probably the intern issue. A lot of them have unpaid interns, and I am always concerned that, you know, God forbid somebody files a lawsuit or challenges that arrangement, that it's going to put them in a real tough pickle, given their limited resources.
Now, we've had a couple of questions come in around the topic of foreign workers, like foreign contractors, like overseas, outsourced, that type of thing. Are there any concerns there that they need to be mindful of in terms of employment law, or is that, you know, just kind of talk us through that for a second. Like if they've got contractors overseas, is there anything in particular they need to know about, either in their home state or in the particular country they're working within? What does that typically look like?
That's a great question, and that is a thing that I've thought about a lot, but just was so complicated I didn't include it in this presentation. I know it's very common, and I think there are a couple layers here. One is whatever laws or requirements are in that country, which might not be as immediate concern for you, but there's that layer there. And then for you as a company to start up, I think it really boils down to, at the end of the day, you know, what type of arrangement is it? I mean, if these are more contractor type workers, then you're much freer in what you're doing, because they're like any other vendor who's performing services for you. That said, if these are people that are truly bona fide employees that are performing work for you day in, day out, depends on the state. I would say actually in some states, there could be some risk that these people will be considered, you know, an employee of your business. And I say that because if the tax authorities involved and they're looking at where your payments are going, they might say you're trying to circumvent the ability to pay the state or, you know, the federal government your payroll taxes. So I hate to punt and say it depends, but it really does. Every state treats us differently. And if there are any specific questions from people, I'm happy to try my best to address them with a particular question.
Great. Another question we've come in, is there a minimum salary below which employees cannot be classified as exempt?
Yes, and it depends on the particular exemption. So many of you might have seen the news that for some of the exemptions, it was double minimum wage, and the federal government's increasing that, I think, next month actually, to, I believe it's 46 or 48,000 a year. I don't have the exact number in front of me, admittedly, but I can easily pull it for anyone that's interested. And that's a major jump for a lot of people. So for people who are managers and are being classified exempt on the basis of their managerial functions, there is a minimum salary threshold that you have to meet. There are other exemptions, like here in California, there's a computer professional exemption, where if you're going to be a high-level, you know, designer and programmer, you have to make, I think it's upwards of 85,000 now. It's an 80,000 range for those people. So your regular kind of just coders who are helping you on a part-time basis, there's actually a pretty good argument they should be paid on an hourly basis. So long story short, it depends, but yes, depending on your exemption, there are specific salary requirements for each of them.
Okay, great. So resources, you know, for these early stage founders, that want to get the right information, the right documents, that type of stuff. I mean, obviously, you know, it's great for them to come to you and engage with you directly to get started with this, but if they're looking to kind of do their own research, you know, at the beginning and scoop up as much information as they can, what's the best place for them to do that? Are there government websites at the state level that are good resources, or should they just forego that and jump straight into, you know, true legal assistance? What do you typically recommend there?
A couple of things I would say. I think, yeah, certainly virtually every state, they have agencies which administer things like wage and hour law and anti-discrimination law, and they have resources you can go to. So, for instance, in California, there's a California Labor Commissioner. They're called the Division of Labor Standards Enforcement. They have a website. The Department of Fair Employment and Housing has a website with materials. So there's certainly that. I would say that depending on your state, Littler actually publishes all kinds of treatises and materials. So for any of you that are interested, I'm happy to provide those to you. There's no charge to that. And that could be a useful tool for you to give you a primer on the key issues. And we update those materials every year, oftentimes several times a year, so they're fully up to date. For those of you in California, one thing that we've developed at Littler, and we're expanding to other states, but for now it's only in California, is we actually have a platform with template employment documents for startup companies. And it's meant to be a highly, highly low-cost option for people who want to do a lot of the work themselves, but just need the solace of knowing that they have documents that are up to date as of the date of downloading it. So there are dozens of startups that we work with all kinds of accelerators and incubators here in California who are using this platform. And if you're interested, definitely email me or call me. I will get you information on that. So if you're in California, that's definitely one resource available to you as part of Littler's partnership with Early Growth Financial Services that we can make available to you. So long story short, it really depends where you are, but if you email me, I'm happy to try to do my best to direct you in the right direction.
Fantastic. Thanks a lot, Kayvan. I think we've just rolled over the hour mark here, so we'll wrap it up there. Again, quickly, Kayvan's information is there on the screen if you have questions after the webinar. And of course, this recording will be made available via email after the webinar concludes. And then it'll be on our YouTube channel as well if you need to do any kind of research back through this presentation. So Kayvan, just quickly, thank you again for joining us.
And thank you again, Jason and Early Growth Financial Services, for getting me involved. I'm happy to have been here, and thank you again.
And thanks to the rest of you for attending today, and have a great rest of your week.